So corrections, I keep hearing you in the background.
Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. It is a Monday. We're running a little bit behind. We're a little bit discombobulated, but here we are, and there's no place I would rather be than here with you guys this morning. Let's start with Judge Glazer in Miami-Dade.
Right, there's no age. It's just aggravated assault with a deadly weapon. Is there a victim here on this case? If so, they need to raise their hand or tell me that they're here.
Not to my knowledge.
Pardon me?
Not to my knowledge. I don't know if there's any.
Okay, thank you. Ma'am, there's probable cause for aggravated assault with a deadly weapon. You're ordered to stay away from the alleged victim, Eduardo Gregan Goody. No contact with that alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim's home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. And also, you may return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing, health items, medication, personal and business-related paperwork, and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay-away order, ma'am?
Yes and no, because the electronic stuff, I would have to contact him to get my stuff, and it would take me time to get there.
No, you have to go there with a police officer one time only to get your personal belongings.
Also, Judge, I have an attorney outside. I have an attorney outside that was going to represent me. And
Who
I
was
wanted
that?
Here, present.
You mean you're talking about the public defender? That's
Yes.
the person standing
That's
next
me.
to you.
It's,
I don't know. There's somebody you keep raising on Samsung. You got to type your name. Who are you?
So-
I don't know. This person wrote I'm here. So he's either a Zoom bomber or the victim, and I'm about to remove him from Zoom. Type in the name of the person you're here for, sir, and I may promote you, or I'm going to remove you from Zoom. If there's any victims here for a case, Madam Interpreter, can you assist? If there's any victims here for a case, please type the name of the case you are here for.
Si hay alguna víctima que esté presente en Zoom y quiera que llame en su caso, por favor escriba el nombre del acusado en el chat. Gracias.
Okay, let's see if it's him. If not, I'm just cutting off Zoom. Okay, that says that's him.
Yes, how you doing, Your Honor?
Hello, can you put on your video and please turn on the
I'm
video?
not very good at this thing, so let me see how
You got to accept the promotion as the panelist, and then you can put your video on. Thank you, sir. There?
Yes.
Thank you.
Yeah,
Good
how you
morning.
doing, Your Honor?
Hi, please raise your right hand to be sworn, sir. Do you swear
Yes.
or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
I do.
Thank you. Please tell me your name.
Eduardo Gaudi.
Are you afraid of Natasha Melendez?
I I am afraid of Natasha Melendez because I think she has a heavy mental problem.
Okay, so you want a stay away order?
I want to stay away order, but I
I
would
just
like
read her
her,
the stay away order. Anything else?
I think she has to get psychological help. She's been talking to herself. She's been doing weird things.
Okay, state any questions?
Yes, Mr. Gowdy, how old are you?
I'm 66.
Thank you. That's the only question I have, Judge.
Okay. So there's probable cause for the second-degree felony aggravated assault with a deadly weapon on a person age 65 or older. Anything else by the defense? Okay, so the offset of bond, it's $5,000. And ma'am, you can only return to the victim's home one time only with a police officer to retrieve your personal belongings. If you go without the police or if you stay there, you will be arrested. Good luck to you.
Okay.
Thank you for coming in. Have a good day.
Thank you, Your Honor. Well,
Right, next we have Anisha Green.
no me preguntaron. Nada.
Let me, Morning. You were arrested for throwing or shooting a deadly missile and criminal mischief. It's from September 12th. I will appoint the public defender's office for you. So give me a moment to review the arrest affidavit for probable cause. So it's the victim's driving his Tesla down the street on Brickell, and I guess it has a video, and it showed as he's doing a turn down the street, I guess on the 13th Street. The defendant is seen stepping off the curb and launching a large concrete rock at his passenger door. And he's back on Brickell, and I saw the defendant again standing on the median in Brickell in front of the CVS, so he alerted a police officer. There's no value for the damage, but given that she launched a large concrete rock at his door, it's probably over $1,000. Ma'am, you are ordered to stay away from the alleged victim, Pablo Verdi. No contact with that alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties, and you must stay at least 500 feet away from the victim, his home, school, and place of employment at all times. Do you understand the stay away order?
Yes, Your Honor.
All right, I'm setting a bond. Count 1, throwing or shooting a deadly missile. I'm setting that at $10,000. Count 2, criminal mischief, will be $1,000. Have a good day.
Thank you.
Jennifer Erickson is next. Page 4, 3 cases. Good morning, ma'am. You were arrested for grand theft of a vehicle, possession of cocaine and drug paraphernalia, and driving with a suspended license, third or subsequent conviction. I will appoint the public defender's office for you. So she's driving a stolen vehicle. Looks like there's open case, an open misdemeanor set for trial. So I'm setting a bond. Count on grand theft of the vehicle, that's $2,500. Then F25-20650, possession of cocaine and possession of drug paraphernalia. She had a pipe with some, it looks like 3.3 grams of residue in another pipe. It'll be $1,000, count 1, $500, count 2. And then F 25-20649, driving with a license, a suspended license, third or subsequent conviction. Let me just see if there's PC for that. Yep, there is. That fine will be $2,500. Have a good day. Izzy Green, page 4. Good morning, Ms. Green. You were arrested for possession of cocaine. I will appoint the public defender's office for you. You're out on felony bond. Let me see if there's probable cause. If there is, there's a hold for you to see the judge tomorrow for F 25-20125. All right, there's probable cause for the charge. I'll set her bond at $1,000, but you got the hold to see the judge tomorrow. Have a nice day. Next is Shanti Hernandez. Good morning, ma'am. You were arrested for aggravated battery with attempted aggravated battery with a deadly weapon. Can you afford to hire a private lawyer?
I couldn't hear, Your Honor. Can I
I'm
afford
sorry.
what?
Can you afford to hire a private attorney?
I have an attorney, Your Honor.
Who is that?
Mr. Green, I would assume, I thought he was going to be here at 9:30.
What is his first name?
I don't recall his first name because this is my first time
You want me to
working.
reset the case in the afternoon to see if it comes in? You have to call him. Or I can proceed now, read the stay away order and set a bond. If you want to proceed without a lawyer, you can waive the lawyer's presence if you like.
Yes, Your Honor, I'll continue with you and continue with your bond. Thank you.
I'm sorry,
Yes, Your Honor, I will continue.
proceed now and
Yes,
waive the
ma'am.
lawyer, or do you want me to reset it?
They told me just to see you, so I'm doing what I was told, so I will proceed.
Okay. You want to waive a lawyer's presence so I can set a bond now?
Yes, Your Honor.
Okay, thank you. Let me review this for probable cause. So there's probable cause for aggravated assault with a deadly weapon. You are ordered to stay away from Lisette Rodriguez, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do you understand the stay away order?
Yes, Your Honor.
All right, thank you. It's a bond is $5,000. Have a nice day.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Once again, happy Monday. A lot of courts still coming online, a few things going on. Let's stay in Florida. We'll go say good morning to Wade Mercer.
Good morning, Ms. Clark. You're here because you have a holdout of Holmes County. I looked at that warning. It was a violation of probation warrant, ma'am, and there's no bond on it. Ms. Clark, you're going to be held with no bond until you can get to Holmes County and get this allegation resolved. I do not know when you'll go to Holmes County. It could be tomorrow, the next day. It could even be today. But when you get to Holmes County, you'll go to another first appearance in front of a local judge there. You have any questions, ma'am?
No.
Have a good day. Shelby Cook. Mr. Cook, good morning. You're here because you've been accused of 5 new charges. Mr. Cook, I've read the complaint. There is probable cause for the 5 charges. They're resisting an officer without violence. 3 counts of possession of controlled substance, which are all different substances, and 1 count of possession of drug paraphernalia. Mr. Cook, I think you're entitled to a bond because it looks to me like you're not on any probation and you don't have any charges pending. Let me see if Mr. McDaniel or Mr. Mitchell have any additional information before I set that bond. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
Just that he be subject to random UAs.
Thank you both. Mr. Cook, I'm going to set your bond at $7,500 each on your 3 controlled substance charges based on your criminal history, $3,500 on the paraphernalia, $5,000 on the resisting without violence. Mr. Cook, when you add those together, you get a total bond of $31,000 cash or surety. You do have a condition of random urinalysis, Mr. Cook. So there's a condition of random urinalysis if you ever are on bond, or from this day forward, essentially, you've got that condition. Mr. Cook, you'll get to use the phone in a few minutes, sir, to try to post the bond. I'm going to ask the jail to give you a notice for your next court date, which should be October the 7th at 8:30. Is that right, Mr. Mitchell?
Yes, Your Honor.
October 7th at 8:30, the jail will give you that notice. You will not get a notice in the mail. The notice they put in your hand will be the only notice you get. So if you do post bond, that's your court date. Do you have any questions, sir?
How much was it altogether if I bond out?
31,000, but you can go through a bondsman. So the bondsman would charge you a percentage of that, and that's something you negotiate with the bondsman.
All right, that's fine. Thank you.
Have a good day.
You too.
Alexander Adan. Mr. Adan, good morning. You're here because you're accused of violating terms of your county probation in 25-86 CT. Mr. Adan, I'm going to appoint the public defender's office to represent you. I'm going to ask that you listen to Mr. McDaniel, and he's going to tell us where we stand in your case, sir.
Your Honor, I spoke to Mr. Dan at 2586 CT. He's going to enter a plea of no contest or he's going to admit that he violated his county probation in this case number, with the understanding the court's going to sentence him. Just remind the court, he has 1 day jail credit. Just remind the court, he voluntarily come in and went to rehab. Apparently some of the religious components of it were outside of his grasp, and he just did not get along very well with that. He did leave. He did also, Your Honor, come and turn himself in at the jail when he got out. He's come and turned himself in. We just asked the court to sentence him and on the driving offense, and he's going to move on from this.
You told me something I didn't know now. The warrant was issued on the 17th. When did he turn himself in at the jail?
Last night.
On the 21st. So he didn't turn himself in when he got out of the program.
No, sir. May I?
Sure. There was a warrant the same day he left, or the next morning. Go ahead, Mr. Gibson.
Mr. Dan had called me on the 15th and wanted to know could he terminate his probation. I told him he could not terminate his probation because we modified his probation for him to complete the inpatient drug treatment facility. And I said, so you got to stay there. Your probation terminates in March of next year. And on the 15th, he said he was staying and there was no problem. Everything was good. Well, the next morning, I got contact, or after lunch the next day, I got contacted by Chrome Ministries that he had left that morning. And
so that would have been the 16th?
Yes, sir. I'd been in contact with his wife. I called trying to find out where he was at. She wasn't sure where he was at. He was supposedly in Alford, so he did not turn himself in the day after. I told his wife he needed to turn himself in. I think he was allegedly staying at his sister's house in Alford. I assume he did turn himself in on Sunday. So he did not turn himself in after he left the facility. And the discussion I had before the affidavit and the warrant was issued, before he left, was that he was going to stay. He did, however, Judge, when you modified the probation, he had a condition that he had a $300 fine balance. You allowed him to do 20 hours of public service work at the facility. So he did do his 20 hours of public service work. That was documented, and his fine balance is $0.
Thank you. Mr. McDaniel, anything to add, sir?
No, that's all accurate. That's correct. And I mean, he didn't, I don't think he knew the warrant was out there, but he knew it was coming, so he kind of turned himself in.
Okay. Mr. Mitchell.
I guess for clarity, is he just playing straight up to the court?
I'm interpreting that way. Mr. Dan, if you enter this plea, I intend to sentence you to 9 months in jail, which is what to my memory, every case like this has been sentenced to 9 months or a year in some cases, unless it was one that carried a maximum of 60 days, which is really, really rare. Yours carries a maximum of a year. Mr. Dan, knowing all of this, is this the admission you would like to enter, sir?
Yeah, I'll take it.
Mr. Dan, I'm going to accept your admission that you violated the terms of your probation in 25-86 CT and will revoke that supervision. I'm going to sentence you to 9 months in the Jackson County Jail. I'm going to give you credit for the time that you've served in the jail, which is, he should have more than 1 day because he had,
Hang on, I'll check.
did he get brought to first appearance and not when he got?
Yeah, remember he come in at
So
first
it's just
appearance,
1 day?
he voluntarily had went into the rehab and, then he come in and admitted Stacy that he had been using drugs or something.
I think at that time he was in good standing. I think you're right. So you got 1 day credit. Hopefully you'll get in the trustee program and get you some extra gain time. But you do have court costs and fines remaining. No, or he got those worked off. So you got nothing else remaining except the jail sentence, Mr. Dan. No probation to follow, sir. Sorry that program didn't work out. I do wish you the best, sir, and get this all behind you and move on. Mr. Dan, do you have any questions?
Good luck to you, man.
Next case is Desmond Baker. Mr. Baker. Mr. Baker, good morning. Mr. Baker, good morning. You're here because you've been accused of 1 count of altering or destroying or concealing physical evidence and 1 count of possession of cocaine. I've read the complaint. There is probable cause. Your criminal history is not bad. I see a conditional release violation a little less than 2 years ago on a misdemeanor. That's all I see. Mr. Baker, I think you're entitled to a bond as far as I can tell. So let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel.
Nothing, Your Honor.
Mr. Mitchell.
No, Your Honor. Oh, but he'd be subject to random UAs, of course.
Thank you. Mr. Baker, based on your criminal history, I'm going to set you a little lower bond than I might normally set. I'm going to set $3,500 in each count. That's lower for a felony. Your total bond is $7,000, Mr. Baker. You have a condition of random urinalysis from this point forward. Mr. Baker, you also have a condition that you appear at your next court date, which should be October the 7th. October the 7th at 8:30. The jail will give you a notice for that day. I'm going to ask Corporal Brown to give you that notice. Mr. Baker, if you post bond, whether you post bond or not, that's going to be your court date. You will get to use the phone in just a few minutes, sir, to contact friends or family to try to post that bond. Mr. Baker, do you have any questions?
No.
All right, we wish you the best, sir.
Thank you.
Yes, sir. Tia Rivera. Mr. Rivera, good morning. Mr. Rivera, you're here for first appearance charged with 1 count of driving while license suspended or revoked with knowledge. Mr. Rivera, there is probable cause in your complaint, and your criminal and driving history is very concerning. It shows 1 prior driving with license suspended unknowingly. And according to what it looks to me like you've got 1 of these pending in Georgia and another one pending in Florida. I think they're both unknowingly. But you have 2 pending, it appears. And you've got 1 that you've already been convicted of. So I think you're entitled to a bond, but those are factors for me to consider in that bond. Let me see if the attorneys have any additional information or corrections to what I think I'm seeing. Mr. McDaniel, anything on behalf of Ms. Rivera?
No, you're correct, Your Honor. I just let the court, just be aware that it's for financial reasons, for not paying a ticket, and not the sin that they're not concerning, but, just no violence or anything. I don't think she's ever been convicted of a crime before. So we'll take that into consideration.
I think you're right. She had a prior PTI in felony court, but no convictions. Thank you, Mr. McDaniel. Mr. Mitchell?
I guess for clarification, I believe the amended offer was 6 months probation that she had.
6 months probation with 10 days in jail
With
was the
10 days in
offer.
jail. Okay.
Because she has 2 pending. Now, if she gets her license, obviously that very well may change.
Yeah.
In fact, it probably will change under the statute that if you get your license, that very well may change, but you've got to get your license and not have certain felony convictions, which you don't. So, Ms. Rivera, getting your license before your court date is going to be very important. I know Mr. McDaniel's told you that. Ms. Rivera, I'm going to set your bond based upon you having 2 of these pending already at $5,000 cash or surety. You've got a condition not to drive a motor vehicle at all. If you get a license, you come back to court, you request permission to drive. We'll take a look at whether that Georgia case is resolved or not. And I'll certainly consider that. And if you got everything resolved, there's an excellent chance I'm going to give you permission to drive. But until then, get your license. Still can't drive. because you can get your license possibly without resolving the Georgia matter, and I want you to resolve both of those before we see how that affects your license. So you've got a condition of $5,000 cash or surety with a condition not to drive a motor vehicle, and you will get to use the phone in just a few minutes, Ms. Rivera, to try to post that bond. I'm also going to ask the jail to give you a notice for your court date, which will be when, Dawn?
October 27th at 9 o'clock.
October 27th at 9 a.m. will be your court date, Ms. Rivera. Ma'am, do you have any questions?
No, sir.
All right, ma'am, wish you the best. We have Henry Armstrong next.
Yes, sir.
Mr. Armstrong, good morning. Mr. Armstrong, looks like you were arrested this weekend. The judge set you
Yeah,
bond
it
and
was
new
a
charges, but the judge, let me
bunch of
finish.
garbage.
The judge held you for 24 hours until I could review the bond you were already on. I did look at that this morning. I also read the new complaint. Clearly, there's probable cause, as the judge found. I'm going to revoke your bond. So in case number 25396, which is the charge from a few weeks ago, you now have no bond. You're going to be held with no bond. You can get that case resolved. I'm going to ask the jail to give you a notice for your next court date. And the new charges, which should be October 7th at 8:30, that'll be your court date for the ones you just got arrested on. Mr. Armstrong, the judge put a condition of no contact on the weekend, so that still applies from this day forward. Mr. Armstrong, do you have any questions?
Yes, sir. You guys
Okay.
are aware of my executive clemency certificate. It is an ongoing lifetime certificate.
So are you saying that applies to future crimes?
That applies from henceforth to, just like it says.
Yeah, somebody's
And
giving you
not
some bad
only in the state
information.
of Florida, but in
that doesn't-
every
that's
other
not true.
state, in military court, prison, probation, everything.
So you're saying if you get charged with a crime in the future, you can't be prosecuted?
Just get
That's ridiculous.
Okay.
Have a good day.
No, it's not ridiculous.
That's all right, Henry.
Did you tell him that, Mr. McDaniel?
Judge, we all know.
I shouldn't have asked that. I shouldn't have asked that. Don't answer that question. I've never heard that particular argument before.
Else lawyers getting to him.
I
Yeah.
was trying to, we all.
Let's go
there's
with
some issues with Mr. Armstrong.
Yes, sir. We've got, I believe we have two left, Julian Wallace and Zachary Davis. Zachary Davis III. Let me see both of those individuals because I think they're the same for first appearance purposes. Which one of you gentlemen is Mr. Wallace? All right, so we have Mr. Davis on my right. Mr. Wallace and Mr. Davis, I'm suing you at the same time because you're both accused of violating the terms of your probation. Mr. Wallace, you have a no bond warrant signed by Judge Garcia. Mr. Davis, you also have a no bond warrant signed by Judge Garcia. So what that means is you're going to be held until you can get over to circuit court. We're going to give you a court date in just a second to see if you have any questions, but first I need to go ahead and get you arraigned. If you'd like to have an attorney appointed to represent you in your VOP, then we're going to get that done today so that you can get that attorney started on the case. Mr. Wallace, would you like to have an attorney appointed to represent you?
Yes, sir.
Perfect. Mr. Davis, same question.
Yes, sir.
I'm going to appoint the public defender's office of the 14th Circuit to represent each of you. Listen to Mr. McDaniel. We'll see if you have any questions when he gets through.
Your Honor, we're going to interplead not guilty. I set this on October 9th, pretrial docket. And I advised Mr. Guy Green to come by and talk to them prior to that hearing.
Thank you, Mr. McDaniel. Mr. Mitchell, anything?
No, Your Honor.
Mr. Wallace, any questions, sir? Wish you the best. Mr. Davis, any questions?
No, Your Honor.
Wish you the best, sir. Corporal Drown, that's everything I had on my list. Anything else?
All right, well, he's finished up now, and I'm going to go search through my filing cabinet for my executive clemency certificate because I think that's probably important to always have on hand. Sounds like something you should carry in your wallet at all times, or at least have a digital copy on your phone. Let's go to Texas, Judge Stevens.
I don't know what Mom said. I know, I asked her that, but she was like, beat that.
You're Monica Vincent?
Yes, sir. Come in front of me, please.
Almost.
Then touch the right hand.
She pleading to both or one?
Both. You're gonna, who's up you got? Okay, ink up your right thumb print. Okay, place it flat right there. Get up one more time. Okay, and place it flat right here.
Yeah.
Alright, this is my note. Thank you.
Two cases are called 24 CR 2342 and 25 CR 1200, both styled the state of Texas versus Monica Vincent, also known as Monica Lynn Vincent. I have some addresses here. I have 6400 32nd. It says 32nd, 64th Street. That can't be right. I grew up in Groves and there's no such thing as that. And then I've got 1199 Dolly Drive.
That was my house, but I had to let it go.
You had to, okay, the most recent address is going to be 6400,
Yes.
32nd?
Yes, sir.
Okay.
Y'all, did you get it?
You try that soon.
I tried refreshing. It's not coming up, so. Just work. I have this, if we need it.
All right, in 24 CR, and by the way, does the defendant waive formal readings of these indictments? Can we proceed? In summary, Mr. Turkis, her attorney.
Yes, Judge.
In summary, 24 CR 2342 alleges that on or about October 15th, 2024 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. You understand what you're charged with?
To go on count one on both these, Judge.
Just count paragraph one.
Paragraph one is fine.
And 25 CR 1200 in summary, it alleges that on or about July 8th, 2024, in Jefferson County, Texas, you committed the second-degree felony of illegal possession of a controlled substance, namely phencyclidine, PCP.
Here.
Do you understand what you're charged with in these two cases?
Yes, Your Honor.
2342. It's a third-degree felony, which means you are facing no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 to be assessed.
Yes, sir.
An agreement's been reached in that case where you would be pleading guilty. And sentenced to 5 years in prison to run concurrently with the next case, 25 CR 1200, you're going to be dealing with here. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
We're going to hold that one in abeyance for just a moment. We're going to go to 25 CR 1200. This case of illegal possession of phencyclidine, if convicted, this is a second-degree felony, which means you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement's been reached as well. In this case, you would be pleading guilty, sentenced to 5 years in prison to run concurrently with the other case. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in each of these cases, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1 in each case. Did you sign those documents? Understand them, discuss them with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
Okay.
Without objection, it's submitted. In each of these cases, State's Exhibit 1 state that you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You were guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record in each of these cases. Pre-sentence reports away to you?
Yes, Judge.
I will follow these agreements and find you are indeed mentally competent to enter these guilty pleas. They are freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt, and I so find you guilty beyond a reasonable doubt in each of these cases. I'm following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years confinement in each case. These sentences shall run concurrently. Do you understand what has happened today, ma'am?
Yes, sir.
So, what are you going to do with your life
I plan.
from here on?
Yes, sir. I was planning on going to the TDC and learning, welding for sure, and getting a trade, so I can come out and
Be independent.
be independent and work. And I actually feel like a turn of my heart with some, like, I'm like 40 years old, and I just, and I feel that's time to make a change and do what I'm supposed to do as a citizen.
Changes are good. Yeah.
I appreciate your,
Make the right changes, right? You know what's right, you know what's wrong, yeah.
I don't have grandkids yet, but I have kids. And I was good to them for the first 12 years. So they're 19 and 17, but I feel I want to be a good grandparent that I could as much be with my kids, but they're doing well.
If you're doing better with the role modeling now, huh?
Yes, sir.
Okay. Well, it's all about choice making. You know what the right choice is, you know.
Yes, sir.
You've had to pay prices in the past and here now. Just fix this. It's just a matter of free will, make the right, you know what the right choice is.
Yes, sir. Thank you.
You can do it. You can do it. I trust that. Okay. Good luck to you, man. Thank you.
Yeah.
Dare I say it, that Judge Stevens was suggesting that the person do the next right thing. Just saying. In our efforts to do 9 to 11% more Judge Boyd, let's go to Judge Boyd. She has what appears to be a fairly young man approaching her.
All right, so where are we on discovery?
Judge, just recently, and I say recently, 10 days, 2 weeks ago, I got a 2 terabyte storage thing full of discovery.
Okay.
This morning, I hear there's more that just developed Friday.
This is the co-defendant to the case we had on, one of the co-defendants to the case we had last week, where I let the court know that I was going to be meeting with the law enforcement agency and receiving additional discovery, which I did. So I have another hard drive worth of discovery that we did not have before that I now need to tender to
And
Mr. Aguilar.
She asked me to bring I think another terabyte with the another terabyte storage container, or data storage to bring. And at the same time, while this is all going on, I would like the appointment of an investigator.
Okay.
I did file a motion sometime back. I have my copy.
All right, I'll sign your copy. I will tell you, if it has been tendered to me, I sign all make sure I've reviewed everything
Okay,
and signed
okay.
everything, but just in case.
It got filed in late August, I don't know.
Oh, then that should have been signed. I sign all of them, I review all of the motions, and the ones that legally I can sign, I will sign them the same day I
We
receive.
just learned that you did sign back in March, an order for a psychiatrist.
Mhm.
That interview was done, but the psychiatrist said he didn't have a copy of the order. It hadn't been entered it properly or something. And he needed to do a follow-up evaluation.
All right, so what I want you to do before you leave here, if you'll go to the back and make sure that they have the order in the system, and this is that. All right, so what we're gonna do on this is the final setting for discovery. There will be no more settings for discovery. Norma?
Yes.
And if y'all decide to go to jury trial, this trial is probably gonna end up happening perhaps in the new year. We shall see.
I was gonna say my second chair, who's not available today, is her calendar jammed all the way through. I think the last jury's possible is December 1st. I think we got, in another case, we have that last setting.
Well, of course, this is the 187, so we'll probably be in trial, but I realize
Yeah.
Megan is smiling. But I always give the staff a long Christmas break because I know people have to shop. Now I have to shop. You know, when you have little ones and Santa comes,
And
you got to do the shopping early. You can't say I'm going to shop, the day after when there's a sale, because they're like, "Where's Santa?"
And there are certain people that have to prepare certain foods.
There you go. All right, so this is what I'm going to do. And state, you need to be prepared to tender an offer on this day. Norma, recall this for November 3rd. That gives everybody an entire month to look through discovery and make sure everybody has everything. And state, you'll need to be prepared to tender an offer on that day.
Yes, ma'am.
Is there anything else?
You said October 3rd,
November 3rd.
November 3rd.
Yes.
Thank you, Judge.
Now, why should I be here when it's my birth month? I have no idea.
Well, is November your birth month?
Oh, yes.
Also, can we just come back in January then?
What are you doing here?
I'm here, my leg's hurting now. Oh, bad.
All right, can you call Amy Owen back? All right, thank you for dressing appropriately for court.
Thank you, Judge.
Thank you.
Oh,
She's on page 1.
It's not broken, but it's swollen. It's about twice the size of the end.
Here.
I don't know.
I will tell you, my level of medical expertise comes from movies that I have watched. Yeah.
So it's nice shades of black and blue.
What did you do to yourself, Adam?
Hiking, and then I fell, I went down, just my shin landed right on a rock. And it was, so, yeah, I thought it broke something, but the X-ray was clear. They're like, no, you're just very, very, very swollen.
Well, I'm glad you're okay, but when you say you fell on a rock, and since it's October almost, that reminds me of Charlie Brown. Yes, you have.
Your flowers are extra ornate today.
Thank you. But you know what? They've been here all week. And so here's the funny, well, not really a funny thing, but here's what I have to investigate on.
Okay.
So supposedly these are beautiful.
Yes.
They're real flowers.
Okay.
They last an entire year.
Is the butterfly real?
Yes. You know so much about this stuff.
They're cool though. The gladiolas are beautiful.
Okay, let me just tell you, I saw the gladiolas and they were $3.
Where?
And 95 cents.
Like at Trader Joe, HEB. Okay.
And so all of those were like $3.
Oh, lovely.
And I love gladiolas, right?
They were like my grandma's favorite. So it's a special spot in my heart.
My
Satin
grandmother
peonies.
would have that, and she had the Rose of Sharon. So
I don't know the Rose of Sharon.
the Rose of Sharons are beautiful, and you really can't kill a Rose of Sharon.
I'm sure I could.
No, you can't. Although the snow killed mine, but I have another one. But the bees love Roses of Sharon.
So I know which one this is.
Yes.
Okay, I know which one this is.
So I got the gladiola. I'm like, I just throw it in the vase, right? So Adriana's like, Judge, let me handle this. I'm like, okay. So she's like, I know how it should be.
Yeah.
I'm like, thank you. But, the cases we deal with, you gotta have some beauty.
Exactly. And that's why I went to like a flower arranging class one time by this floral person that works with like an interior designer I like. And that's kind of what I was saying. It's just like, we deal with so much ugly stuff. It's nice to like deal with something pretty every once in a while. So
And then you can turn around and say, hey, there's beauty in the world.
there's a really cool place if you're ever in Austin. It's I think it's just like a generic name, like Austin Flower Shop or something. But they have these crazy flowers. You can go out there and get like everything by the stem. And you can arrange like these beautiful bouquets. But it's all these like amazing, like unusual things. So I love to up there and just whenever I'm there, I go and get like a couple different things and make little bouquets at home. So
And you have to let me know when you go.
definitely.
Then I'll be like,
And like, I'm not a big carnation person, but like during Halloween, they dye them these crazy cool colors, like these blue and oranges. So I always think it's some like the holiday carnations. So I had to go up there a bunch because my rental house is in desperate need of repairs. So I'm gonna be there a bunch the next month.
all righty.
Well, thank
Have a good one.
Thank you, Judge.
Thanks. Hi, Adam.
So Judge, when do you want us back?
Well, I had said the 24th.
I'm gonna
but-
follow up with my doctor on Thursday or Friday if it's not significantly better, and then
So
hopefully avoid
If you
surgery.
want, Amy Owen was here. She said the 29th actually works better for her. But I told her, I know you were going on an Alaskan cruise or something.
No, I took that trip. That was a couple weeks ago.
Yeah. Oh, no, she said this week on Wednesday. So my question is, are you available for the 29th?
Yes, ma'am, I can make it the 29th.
All right, Norma, and if you'll let your client know.
I will.
All right, Norma, put that on the 29th. And we'll do jury selection on that in the afternoon.
This has been Flower Talk and Medical Advice with Judge Boyd. Thank you for joining us. Let's go back to Judge Stevens.
Oh, almost 3 months ago, and I think this has been said a few times, but because of your inability to be here, it's been postponed. We're going to have it right now. The defendant is charged here in this indictment with the second-degree felony of aggravated assault that carries with it up to 20 years in prison. And this motion states, well, it's a general motion that's just stating that it's insufficient. Yeah, I don't have enough information from this to understand what it is. So, Mr. Ham, on behalf of the state, y'all filed the motion. What is it about this motion we need to take up?
Well, the remainder of the paragraph 3 indicates, Judge, that he specifically was communicating directly with the victim on May 24th, 2025. That victim's name is Eduardo Mendez. It occurred in the general public there at a gas station on Washington. Mr. Mendez was with another individual, and when Mr. Mears came in, they saw each other. While my victim was inside the store, he walked in. He being Mr. Mears walked in, approached him, began yelling at him about the aggravated assault case. My victim tried to get away from him in the store. He tried to start a fight with him, swung at him with a closed fist. He was able to move out of the way to avoid that. At that point in time, Mr. Mears left. Mr. Mendez proceeded with police reports, filing charges as far as that is concerned. That's how we picked up with this report. And my detective that's involved with Mr. Mears informed me about all this. They did not have a working camera system inside the store for surveillance footage to support it. And frankly, I would have had the victim present here this morning to relay that information, but I was unsure whether or not Mr. Kopp was going to be here. Our last communication was that he did not feel like he would make the trip today. So if we need that, I can, this information is literally a phone call away from me to obtain, Your Honor.
Can we get him over?
I can either get him or the detective here to talk about it.
Well,
Your Honor, I thought we were going to go trial day. That's one of the
we are, but my trial docket exists on 2 full pages and only one to be tried at a time, but we're gonna take up the hearing.
I was like,
Speak. Let me speak.
sorry.
Thank you. We're gonna take up matters when it concerns orders of the court and the security of people involved with trials. Those become important. And we'll deal with that. But I can only try one at a time, and I'm going to name, we'll get the trial docket going, but I'm in another trial, finishing the punishment phase of a continuous sexual assault of a child. That would be finished this morning, then we'll pick a jury this afternoon. But it may or may not be this case, but we are going to take up this matter. You don't leave the building. You don't leave the building until I tell you otherwise. Mr. Santat, because the court does not tolerate defendants who fail to follow the conditions of bond, such as approach, communicate with the complainants. That's forbidden.
Because of the sensitive nature of all that, Judge, is why I filed it and have been trying to get a hearing for.
We're gonna have a hearing today?
Yes, sir. Yes, sir. And I can get, as I said, I can get at least the detective here.
You stay in the building and be close by so that we can pull you in here for the hearings when we get to it. Right. All right. Who else has dispositions? Right? Did you have one?
Yes, sir. I turned in the packet.
Who is it?
Oh, Joseph Lyden, Your Honor.
You need something to make.
I just, Mr. Hand has it.
Y'all are gonna take care of that over there. Thank you. Joseph Lighton? Joseph Lighton, that's you? Did you sign everything?
Yes,
You
sir.
just need to speak.
Okay, come on up.
Raise your right, sir. Raise your right hand, you swear or affirm the truth, the whole truth, and nothing but the truth, so help you God. You have your right thumb print.
Arias Wilson hired me, so they don't have father. No, sir. She said. So let me do that.
24 CR 524 is now on Texas versus Joseph Lighton. That's you. Mr. Lighton, Right, Kindler, your attorneys and state's attorneys present. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
So a
summary, this indictment in 24 CR 524 states that on or about February 20th, 2024, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon, namely a firearm. Do you understand what you were charged with here, sir? Yes. If convicted of a second-degree felony, you face no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand? Yes.
Speak up, Judge. Yes, sir.
We're hung up somewhere.
It's
working its way
through.
through.
The channel towards us.
It's over. It's in someone else's hands right now.
2 seconds, Judge.
Oh.
Okay.
You go.
Oh,
Okay. Tip me off on this, guys, when y'all do this. You're going forward on the lesser included offense of Class A misdemeanor assault. Is that right?
That's correct.
Okay, which carries with it a different set of punishment, up to 1 year in the.
It's the admonishment for foot syndrome. He's been.
I know, but I have to. I gotta make sure that you can sign all day long, but we still have to go over in the record when a plea is made. So the parties. One thing is punishment. That's. A Class A misdemeanor of assault carries with it up to 1 year in the county jail and a fine up to $4,000. Do you understand?
Yes, sir.
An agreement further has been reached. Where you'll be placed on deferred or unadjudicated probation for 2 years, fined $500. Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal, and then $500 is a fine. There will be terms and conditions of probation which are normal and customary for this type of offense. And if I follow this, you have no right of appeal of your case. Do you understand? You have to speak out.
Yes, sir.
Okay. How do you plead to this lesser included Class A misdemeanor of assault from this indictment, which charged you originally with a second-degree felony of aggravated assault? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty of this lesser included Class A misdemeanor of assault?
Yes. The court will note I exercise portions of the judicial confession that are no longer applicable since it's a lesser included offense. So I want to draw the court's attention to that. And those are issued by myself and the defendant.
Hey, I need this. I've sent it back to you. Can you send it back to me? Because I'm unable to make the necessary writings on it. Thank you.
It's back in your.
Okay, I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 110.
Without objection.
Without objection, removed. Among other things, this that you are mentally competent to enter your guilty plea. It's really involuntarily made. You know what you've been charged with? The indictment's been read to you. You've read it. You are guilty of the lesser included offense of Class A misdemeanor assault under this indictment. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witness. Be satisfied with the representation provided by your lawyer. All of this is true of states. So help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
So waived.
I will follow this agreement and find you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting the guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am going to defer any finding of guilt, place you on deferred or unadjudicated probation for 2 years. There will be a fine of $500. There will be other terms and conditions of probation. You do well. It will be shortened and you can move on with your life. Okay.
Thank you.
Please see the probation officer. Thank you.
Joseph. Yes, we're talking. No. Yeah.
Any other? Please. Yeah.
She was on the trial docket this morning. They revoked her for not. I think she had a child care issue, and that's why she's fine up there. She's how old is she doing?
Yeah.
Who is this? Who is this lady?
I'm sorry, Judge. On your trial docket is Miss Sterling Booker, and remember you had called her and she was not here. And she was running late, and she had a child care issue with her 8-month-old child, and that's why she was running late. So she was asking and begging the court withdraw the revocation of her bond.
Okay, what happened?
Go ahead, talk.
Why were you late?
Because my child, I ain't got nobody to watch my child when I go to court.
You got to plan that way ahead of time. I mean, we have kids, I have kids. But, I mean, you have to plan those things. You can't wait till the last minute. Who's taking care of the child now?
My cousin.
And when you're late, sorry, you can talk about it all day long, but when you're late, everybody has to see you on time. We gotta move like a train station. Train takes off. You can't run down the track and catch it. Okay, and of course, the bond's gonna be the bond forfeiture is withdrawn.
Thank you.
We'll put it right where it is. But who's on this one, Sarah? Just about ready for trial?
No, Your Honor, I have the same problem that I had with the last case.
She's still in trial now.
I thought she could do two things at once.
She can do a lot of things at once, Cheryl. She's very talented.
He's doing all the talking here, Sarah. How does he know all this information?
It's shocking, I know.
Judge, we understand she's in trial, I understand.
Yes, but she'll be finished here shortly, and then we can pick a jury tomorrow.
Well, except for I'll be out a couple of days this week for my new.
No, you won't. No, you're just saying that because it's true. Who's, well, we know there's an inevitable change that's going to have to be made here. Who's going to take over the case? Okay.
Here's
Yeah, thanks to you. Yeah,
Put that one on
that's
me.
what I understood.
Thank you.
Because it was something you did.
It's all me, right?
You said it's not the same here anymore.
I wish I was this with Harris County.
Okay, let's go back over this. On Gladys Jackson.
And so just have a seat and, well, no, I'm sorry, you gotta get reset.
Yeah, reset.
Right here.
out.
Pick one of Daniel's cases.
Well,
References.
where is it? Getting ready?
He's at a medical appointment today.
Oh, is he gonna be
He
able
is.
to do something this afternoon?
If we need to go forward this afternoon, I will pick the jury for him. My preference is to allow him to pick it in the morning, Judge, so that it stays consistent. If we must move forward, I'll pick the jury.
Got a timing issue.
Yes, sir.
For this week.
But he's ready.
So we've got
And I can step in his stead.
Roberto Mears.
State's ready on that. I've talked with Mr. Cobb. He's visiting with his client about the bail issue and an offer. He'll let us know in
And
just a moment,
Dylan,
Judge.
What about Dylan Banks? Does anybody have?
That's the one that needs to be reset because it requires medical testimony from folks in Houston. Both parties have agreed to that.
It's special set judge and. That's why we left down the.
Mr. LeBlanc hadn't even been in here yet.
I have not seen him, no.
It'd be nice. Jonathan Ramos, Mr. Gertz.
Our preference on this, Your Honor, as well as Mr. Gertz stated that if he's available, he wants to try Miss Jackson.
Yeah, that's what he wants. Who's right there? Is that?
That's Mr. Gertz.
Ryan Gertz?
We're talking all bad about you right here on the.
It would not. Instead of third party here.
Or the last.
It's coming again. Jonathan Ramos. Yes, Judge.
I'd said your preference was to move forward on Jackson if you're available.
Yes, representing her.
And
probably, is probably what you would.
All right, they've fallen into a lot of procedural discussion. We'll keep an eye, though. Let's go to Michigan, Judge McNally.
Your name?
Rosalino Dahlia.
Come on up here, ma'am. Your name?
Angela Ravella.
This is $1,000, right?
Yeah.
Did you cause the accident?
Yeah,
Did you have insurance?
yeah.
Okay, I have to tell you both, before we go on, each of you have the right to have a case removed to the General Civil Division. Each of you have the right, if you do that, to demand a trial by jury, to appeal my decision, to hire a lawyer, And manager, appeal my decision, hire a lawyer, and plaintiff, you have the right to seek in excess of the cap of 7,000, I believe it is. If you waive that right, you're going to remain here. Do you understand that, Mr. Gaglio?
Yeah.
Do you understand it, Ms. Vella? Do you wish to waive those rights, Mr. Gaglio? Do you, Ms. Vella? I'm going to ask you both now to raise your right hands. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God. Mr. Gaglio?
Yeah.
Ms. Vella?
Yeah.
All right, sir, do you have a receipt for how much you spent?
Spent,
The damage to the
car
car?
was totaled out.
Do you have proof of that?
Yes.
Let me see it. And did the insurance company, you had 1,000 deductible?
I had 1,000 deductible. They paid me 4,000 minus the deductible, so they gave me $3,089.
Well, what kind of car was it?
It was a Dodge Dart.
What year? So they determined the vehicle was only worth 4,000 and some.
$4,089. Correct.
Did you have insurance?
Yes.
Did you have insurance?
Yes.
How the accident happened? Can one of you tell me real quick, Mr. Gaglio?
She sideswiped the vehicle, just no signal, no nothing, just went right for it.
Do you agree with that, ma'am?
Sure.
Or don't you?
That's not exactly
Well,
what.
tell me what happened. Were you at fault?
So technically I was, only because I didn't know and I lowered my ticket. I was admitting fault and I was gonna take it to court to like.
Tell me what happened in the accident. I don't want to talk about what happened in court.
Okay, so I was getting over, there was three.
What lane were you in?
I was in the lane that was closest to turning.
I don't know what.
Okay,
What street?
Breland and Telegraph.
Okay, so you were on Vreeland or Telegraph? And you were going north or south?
I was.
Were you going toward Toledo or were you going toward Detroit?
Sure.
Okay, so were you going to turn left onto what would be east, let's see, westbound Vreeland?
Yes,
And was he coming southbound on Telegraph?
he wasn't there.
It was my son.
Okay, what happened?
So I had my turn signal on to turn right into the lane and into the turning lane so we can all turn right. And when I did that.
All right, hang on a second. I thought you were turning off of Telegraph to get onto Vreeland.
Yeah, I wasn't completely in there yet, but I had my turn signal to get into it, and then when
To get into the center turn lane
yes, to turn.
of northbound Vreeland. I'm sorry, northbound Telegraph.
I'm sorry, I'm not familiar with that area. I'm not from that area, so
Do you know what direction you were traveling?
I was going straight.
I don't know what that means. Give me do you have the police report? Anybody have the police report?
I have a ticket.
Let me see the ticket.
The police report was in the flat right, it was, I never printed it out. I just,
Let me see the ticket.
Judge, can I?
Not yet. Let me look at the ticket. I don't even understand where we are now, except Telegraph and Vreeland. Jeez. Driver in left lane, you were in the left lane and attempted to turn right onto Vreeland and did you try to turn onto Vreeland from the left lane of northbound Telegraph? Just let me finish my question. Did you try to turn onto Vreeland right from the left lane of northbound Telegraph?
No, I didn't.
They wrote you a ticket for failure to yield.
And that's why I lowered.
Came in and got impeding.
What was that?
You came in here and got impeding?
Yes.
All right. What did he do wrong? What did this kid do wrong?
So first of all, he sped up and hit me from the side. I have the pictures of the damages on my car too, and it's been totaled. I haven't been able to drive it since then. So I just haven't had a car.
Ma'am, I want you to listen to what I'm telling you. There's a right turn lane there and two northbound lanes there, right?
Yes.
And when you were trying to turn right, did you turn from the left lane of northbound Telegraph and try to get over onto Breland by turning right?
Not completely like that. I was getting into the right lane to turn with everyone else.
Don't you think he had the right of way?
I had
You turned in
enough room to
front of
get
him,
over
right? You
to
turned,
turn.
pardon?
I had enough room to get over because he was like in the back, he was in the back of me. He was already in the turning lane, but he wasn't, I had enough room to where I could get over.
I don't know anything about a turn lane. Were you in the turn lane or the right? You talk about the turn lane to turn right?
Yes,
And he was already there.
but he was in the back, yeah.
You got to yield the right of way to him. I'm sorry. Let me see your documentation here. Whatever else you have. Total.
From the insurance,
I just need to see the damage report.
damage report was on the police report, which is,
You don't have any evidence that your car was totaled or taken to the shop?
no shop, but it was taken into the.
Whatever, to be totaled. I mean, the car was bought out from you by the insurance company. Just show me something that tells me that the vehicle was damaged and that you had to pay $1,000.
You want me to come up?
No, you can hand it right to him.
Yeah, let me get rid of.
I don't think this is really a close call anyway. Give me that, I want to get to these other people here real quick, but
I also have pictures if you like this. You think you get a tow judge? You got it brought to the house?
I got it.
Yeah.
Next time you got to bring damage reports. How bad was?
The tire was gonna fall out, Judge, that's why.
All right, look, ma'am, you owe him the money, $1,000. I'm gonna find in favor of the plaintiff. It's $1,000. It's really an easy call. You can't get over in front of somebody and hit them without being responsible for the accident. So you have $1,000 owed plus 68. Did you have to get personal service? No, it was signed for, right? Did you have to hire a process server?
I did, I hired Dino Guzzi,
How much was that?
16.
Ma'am, you owe him $1,128, okay? Can you pay that now?
No.
When can you pay it?
I'm currently 30 weeks pregnant, so I'm not working yet, and I'm due in November. So I don't know when I could.
You don't want this judgment sitting out there. Do you live on Bassett?
No, I moved and I got a house with my boyfriend.
Where's that at?
26831 Taylor.
26831 Taylor Street?
Oh, no, sorry, California.
26831 California?
Yes.
In what city?
Taylor.
Why don't you get him to help you out a little bit?
I mean, he can if need be, but not today.
Where does he work?
He is a subcontractor for Ford.
All right.
1099,
You think he can pay 50 a week for you?
50 a week.
Correct. Tell you what, you're gonna send these payments. If not, he can start garnishing wages, bank accounts and everything else. $50 weekly. And I'm gonna start it beginning on October. October the 6th. That's a Monday, okay? All right. Now, if she misses a payment, you can come in here and fill out a motion to set aside the installment payment order. Okay? If you will, any questions at all?
None of this.
You can both go down the hall. He'll bring the file down. They'll give you a copy of the judgment for your records. Thank you both.
Thank you.
All right, Fleet Fix mobile truck repair.
All right, let's go back to Judge Boyd.
Has told the court that he's on your bond and that you all have a contract and that you're not abiding by that contract. So when you're not abiding by contract, a bondsman is allowed to remove themselves from your bond. Do you understand?
Yes, ma'am.
All right. So here's my question. Are you going to be able to afford an attorney?
No, ma'am.
So you're going to need one appointed to you?
Yes, ma'am.
All right. So this is what we're going to do. Once we go on the record, I'll make sure that we have those things taken care of. All right?
Yes, ma'am.
Cisneros. I'm going to allow you to withdraw from his case because he can't afford to pay you. I'm going to appoint an attorney, but with regards to your being off his bond, I'm going to need a motion filed for that.
Yes, ma'am.
All right.
And Your Honor, I don't mean to be a bad person or a bad lawyer or anything like that. I just wanted on the record that I posted his bond sometime early December.
Mhm.
And he only paid a little bit less than half, I believe, and he hasn't made a payment since December of last year, of course. And I've told him several times, I don't want the government thinking that I may have gotten paid in cash and I didn't deposit it and I'm not paying my taxes. So I need to protect myself, and that's the only reason. And the only thing I asked the court, and I'll reiterate it once I file my motion, is not to increase the bond because obviously.
No. Here's the thing. When bondsmen are getting off of a bond because of contract disputes, normally the court keeps the bond as it is because there has been no issue other than payment with the bond.
Yes, ma'am.
Now, if it's an issue of not reporting or something of that nature, then the court may take that in consideration. So we're going to get you another attorney. Just have a seat and then you can file to remove yourself from the bond.
Yes, ma'am. Thank you.
All right.
All right, let's go back to Judge Stevens.
Okay, let's move forward. If we are able to.
You guys be over there, buddy.
I got it. In manual.
Hey, you can
That's you?
Yes, sir.
25 CR 413 is called by an argument. Thus, the defendant who's here with Mr. Vasquez waive a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes.
We just on paragraph 1.
Yes.
Paragraph 1 alleges that on or about January 17th, 2025 in Jefferson County, Texas, you committed the 3rd-degree felony of injury to a child or disabled. Actually, in this, it's a elderly person, 65 years of age or older. Do you understand what you're charged with here, sir?
Yes, sir.
This is a 3rd-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 5 years in prison. Is that your understanding of the agreement given? And you will be provided all credit for time served in accordance with this case.
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'll show you here what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence. Without objection, it's admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here?
Yes, sir.
Sir, I will follow this agreement I'm going to find here that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from state's exhibit what admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony of injury to an elderly person. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir?
Yes, sir.
Anything else to add on this?
No.
Good luck to you, sir. Thank you. What was the relation of this person to you?
It's my mother.
Your mom? Is she all right?
Yes, sir.
Okay. Anything else? That is all.
Thank you. Thank you. Yeah, absolutely.
Okay. Any other dispositions?
We have a motion for that case.
You've got two bond hearings that are set as well.
All right, let's go back to Miami-Dade. We'll see how Glazer's holding up as we approach lunch hour.
For work and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay away order? Sir, I'm setting a bond. It's 4,000 count 1 and 1,000 count 2. Good luck to you. They may decide to charge it as an ag back because she was cut with the broken glass. I don't know. It's up to the state. 4,000 and 1,000. Have a nice day. Next is Reginald Harrell. Page 12. Good morning, Mr. Harrell. You were arrested for driving with a suspended license, third or subsequent conviction, and resisting an officer without violence.
What's the substance conviction?
I will appoint the public defender's office for you. I think it's just DWLS. His license suspended since 2022, 2 previous suspensions. So it's just probable cause on count 1 for DWLS. Was he eligible for a program? Let me see. Oh, too many tap, maybe tap alternate bond. Count 1 is $500 for DWLS, and count 2, resisting an officer without violence, is $500. No driving unless you have a valid license, sir. Have a nice day. You have an address, don't you?
Yes, ma'am.
Thank you. All right. You can get out for free with tap or post $1,000 bond.
Tap alternate.
Next case is Donovan Sutherland, page 12.
Bond it out.
Thank you. Bond out. Marco Francis. Good morning, Mr. Francis. Sir, you were arrested for petty theft, 2 or more convictions. I will appoint the public defender's office for you. It's an added charge.
And
It's
he has
from
a
August.
fugitive from Broward.
He what?
He has a fugitive hold from
You have a
Broward.
fugitive hold from
No
Broward.
bond.
So this is from August 15th of 2025. It's alleged he went to the Bath and Body Works store and took merchandise. He took $646 of merchandise. And he has prior convictions. Sir, you are ordered to stay away from the Bath and Body Works store at 14811 Biscayne Boulevard in North Miami Beach, Florida. You are not allowed to go to that store and you must stay away from there. Your bond is $2,500. Have a nice day. Next is Jermaine Laurent.
He refused court, Your Honor.
Let me review for probable cause. Oh, is this second refusal or third?
Second.
Oh, let me review. So there's probable cause on F 25-20588. We'll reset it for the afternoon. And then F 25-20663, there is, let's see. Looks like probable cause for petty theft of first degree misdemeanor. It doesn't mention prior convictions. We'll set them both for the afternoon. Page 13, we have Francisco Martinez. Good morning, sir. It says set for PCH. You got arrested for possession with intent to sell cocaine and driving with just possession with intent to sell cocaine. I will appoint the public defender's office for you. This possession of cocaine doesn't give a quantity. There's probable cause for possession of cocaine. I guess there's no officer here. Officer Diaz, are you here? If so, raise your hands. I'm just setting a bond that you had a large amount of cocaine. It looks like a sale amount, but they didn't put the amount in, the quantity. Ms. Sturgis, what do you want to do? It's
Judge, I'm
Yes.
happy to
I
have
think
a
it's a
bond.
violation of the 48-hour rule. So I'll just set a bond. It's gonna be $2,500. Have a good day, sir. Next is Renee Renaud, page 14. Good morning, sir. You were arrested for robbery by sudden snatching, battery, domestic battery by strangulation, and battery. I will appoint the public defender's office for you. There's probable cause for the charges. It's from September 8th. Do you have to go to the victim's home to collect any personal belongings, sir?
Yes, I do.
All right, you are ordered to stay away from Deanna DeBrio, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the from the victim, her home, school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. And you may return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing, health items, medication, personal and business-related paperwork, and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay away order, sir?
Yes, what if she's not pressing charges?
It's up to the state if they want to go forward with the charges. But right now, I have to do the stay away order. Count one, robbery by sudden snatching is $2,500. Count 2, domestic battery by strangulation is $4,000. And count 3, battery is $1,000. Have a nice day. Do you have money to post a bond, sir? If not, I'll give you house arrest.
How long house arrest gonna take? Cause I gotta go to work and I got bills to pay.
You got money to post the bond? Let me see if I can lower it at all. It's from September 8th, a few weeks ago.
Yeah, please. And house arrest, I don't have a home right now. That's why I pay rent.
Oh, I hear you. All right, I'll set the bond on count 1 at $1,000, count 1. Count 2, the battery by strangulation. I'll set count 2 at $3,000 and count 3 at $1,000. Your total bond's $5,000. All right, good luck to you. Next case is Michael Sanchez Popotier. Good morning, sir.
He's gonna need a Spanish interpreter.
Thank you. Sir, you were arrested for aggravated assault with a firearm and child neglect.
Señor, lo han arrestado por agresión con agravantes, con arma de fuego y por negligencia de un menor.
I will appoint the public defender's office for you.
Voy a nombrarle a la oficina del abogado de oficio para que los represente.
Perdón, que la oficina acá.
I'm sorry, the office of what?
The public defender's office to represent you so you can have a free lawyer. Correction.
La oficina del abogado de oficio para que tenga un abogado gratis para su defensa.
Does he have any immigration hold or no?
No, Your Honor.
Okay. All right, sir, there's probable cause for the charges.
¿Hay motivo fundado para estos cargos?
You are ordered to stay away from the alleged victim, Ovidio Melende Sanchez Mejia.
Se le ordena mantenerse alejado de la víctima, en este caso, Ovidio Meléndez Sánchez Mejía.
And the 2 children whose initials are MS and BS.
Y los 2 menores cuyas iniciales son MS y BS.
No contact with the alleged victims either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto o comunicación con estas víctimas, ya sea de manera directa, indirecta, en persona, por escrito, por teléfono o mediante terceros.
No contact with the victims through social media or other electronic means.
No puede tener comunicación con las víctimas por las redes sociales u otros medios electrónicos.
And you must stay at least 500 feet away from the victims, their home and school and place of employment at all times.
Debe permanecer al menos a 500 pies de estas víctimas, sus hogares, lugares de estudios y lugares de empleo en todo momento.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
No se ve involucrado en ningún tipo de actividad ilícita y no use o esté en tenencia de drogas ilícitas.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No use, compre, esté en tenencia de o porte arma de fuego, munición, armas blancas o permiso para portar arma oculta.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Debe entregar inmediatamente cualquier arma de fuego, munición o permiso para portar arma oculta a la estación de policía más cercana y traer recibo al tribunal.
Also, you may return to the victim's residence one time only within 48 hours of your release from jail.
Además, puede regresar una sola vez a la residencia de la víctima hasta 48 horas después de su liberación.
You must be accompanied by a police officer.
Pero solamente con una escolta de un oficial de policía.
So that you can retrieve your personal clothing, health items, medication, personal and business related paperwork, and work tools.
Para así buscar sus efectos personales, incluyendo ropa, medicamentos, documentación de negocios y personal y otras herramientas de trabajo.
If you go to the victim's home without the police or if you stay there, you will be arrested.
Si se presenta en la residencia de la víctima sin la policía o permanece allí, volverá a ser arrestado.
Do you understand the stay away order, sir?
¿Entendió la orden de alejamiento, señor?
Sí.
All right,
Yes.
thank you. I'm
Gracias.
setting a bond. Count 1 aggravated assault with a firearm is $5,000. Count 2 child neglect will be $1,000. Have a good day.
Por el cargo número
All right, let's change it up. We'll go back to, well, if Ellie quits bumping things. Let's go back to Judge McNally.
A, B as in boy, N as in Nancy, I, C,
Wait a minute. HRAB. Yeah, okay.
I, C, K, Y.
Brad Nicky. Okay, and your name?
What?
I already told you what I said. I know him. He actually did work for me at my house about 10 years ago. Cutting grass or something, right? Wasn't that about 10 or 12 years ago? So anyway, if you want me to get out of the case, I will. If you don't, I'm going to hand it. This question is whether or not I'm biased for or against. I'm not biased for or against anybody. So, but I'll be glad to answer any questions concerning my relationship with him if you'd like. And you can feel free to fire away and I won't take any of that personally. Do you have any questions?
No.
And you don't have a problem with me handling it?
No, sir.
By proceeding in the small claims division, each of you are giving up certain rights. You're giving up the right to a trial. You're giving up the right to appeal my decision. You're giving up the right to hire a lawyer. In plaintiff, you're giving up the right to seek in excess of $6,500. Do you understand that, Ms. Rabnicki? And do you understand that, Mr. Flood? Do you wish to give up those rights and proceed here, Ms. Rabnicki? Mr. Flood?
Yes, sir.
I want to ask you a question, though. What is your position at Fleet Fix?
Yes, we do.
Okay, so you have personal knowledge of the facts and circumstances of this case. Do you have any other witnesses here? Any other witnesses here?
Thank you.
Raise your right hands. Solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. Ma'am?
Yes.
Sir?
Yeah.
All right. Go ahead and tell me why you're suing for $1,021.53.
So Aaron was discharged on June 16th. My boss, who was the owner of the company, reversed payroll for hours worked June 8th through June 14th that would have deposited into his bank on the 20th.
Wait a minute. He was discharged the 16th. He was good, do a check on June 20th. You just said that the office, oh, I see. So why would it be reversed hours between June 8th and June 14th?
Because my boss thought that there was an outstanding laptop and passwords that needed to be returned. So I rectified the situation.
Wait a minute, wait. So go ahead.
So on June 19th, I let Aaron know that I was going to cut a local draft to pay him for the hours worked June 8th through June 14th, plus the hours that he worked on his last day, June 16th, plus a reimbursement that he would have owed for gasoline.
So you were gonna cut a check for the hours worked between June 8 and 14.
Was to cover the payroll that got reversed.
Right, and how much was that? Just those dates first.
The check total was $1,182.88, which covered $1,021.53 for the 8th through the 14th.
$1,021.53, okay.
Balance was for the 1 day work, June 16th, plus a gas reimbursement.
How much was the day work June 16th worth? The point is, what you're trying to tell me is it's $161 roughly, give or take a few cents. It's actually $161.35 that Mr. Flood earned for his work on June 16th, plus the amount that was owed in gas, right? Okay, so then what happened?
So on June 20th, his father picked up the check. Per his request, he wanted his father to pick up the check, so his father picked up the check. He deposited that check. Then on July 2nd, I received an email from our payroll service that the reversal was denied because the customer advised it wasn't authorized, it was improper, it was ineligible. So our payroll service paid his bank back $1,021.53.
Say that again.
Sure. So on June 2nd, or July 2nd, I'm sorry, I received an email from our payroll service saying that the reimbursed deposit was denied,
And that reimbursed deposit amount was for,
$1,021.53,
because,
because Aaron had submitted something through his bank advising that it wasn't authorized, it was improper or ineligible. So at that.
wait a minute. Submitted something through his bank that indicated that what was ineligible. Okay, so they went ahead and they were gonna they wanted to reimburse.
Unreversed reversal, basically.
Okay. And did they reverse the reversal?
They did. And they sent me an email saying I would have to recover that monies from Aaron, and they said that they emailed him as well. So he was effectively paid twice for his hours worked June 8th through June 14th.
Do you agree with that?
No, Your Honor.
Okay, tell me.
So when I started at Fleet Fix, I was promised 40 hours PTO. And then it would be paid out after full 90 days work. I worked there over 90 days. When they withdrew the money out of my account, it came from a separate company. It did not come from Fleet Fix Mobile Truck Repair. As well as when I disputed it,
PTO. What does that mean?
paid time.
Okay, so they agreed to pay you some paid time off after 90 days.
Yes, Your Honor.
And that check came from a separate company.
No, when they went to pull the money out of my account, it came out of the
Okay,
so that's why it got disputed.
Gusto handles our payroll.
who does?
Gusto, I don't actually deposit money into the employee's bank accounts. Money goes to Gusto. Gusto does the deposits for me.
This is a mouthful, kind of. Initially, your boss told you to reverse the payment that was made between June 8 and June 14th because this young man had a password and a laptop that needed to be returned, right?
Your Honor, I did not. The laptop's still out.
Okay. And then you cut him a separate check, right? And that check amount was for $1182.88. And he cashed that check, right? And you kept the money from that check, right?
Yes, Your
And then that included not only the 8th through the 14th, but it included the work he performed on the day he was discharged, June 16th, and gas reimbursement for that date, or for what he was owed in gas reimbursement, for a total of $161.35, bringing the total from $1182.88, right? His dad picked up that check on June 20th, right?
Yes.
That's the check he took back that was deposited, right?
Yes.
Now, you're telling me this payroll services company that does your payroll for you said that he shouldn't have been paid between June 8th and June 14th, right?
No, the payroll service doesn't determine that. What the payroll service told me was, I have the email, that he had disputed the reversal. And so they were paying the money back to his bank. And I had to pay Gusto the amount.
Did you get that second check?
Yes, Your Honor.
So you did get second check from them.
Yes, that should have been 40 hours of PTO that so.
Your Honor, the check clearly stated on it what it was for, and he wasn't owed PTO because he hadn't successfully completed his probationary period because he was on a performance improvement plan. And per our manual, we don't even pay out PTO if you get fired. But the check clearly stated what the check is for.
All right, let's slow down one more second. What day did you start there?
Started February 14th.
And you get entitled to PTO for after 90 days of how much? 1 week salary. Is that 90 working days or is that 90 days period? Would have to be 90 working days, right? And how many days did he work?
He had not completed. He was close, but he, like I said, he did successfully complete it because he was on a performance improvement. Which I have a copy of that.
What does that mean? They had an issue with his work?
Yes.
And they notified him that to him when?
The performance improvement plan was, the meeting was on May 28th.
Do you have the copy of that letter?
Yes.
Can I see it? So we're really down to, everything aside, as to whether or not he's owed for PTO, right? We all agree with that?
That's what it sounds like to me, sir.
Is that right?
Yes, Your Honor.
I also have our manual already.
I've also got state Michigan wage hour,
From who?
Michigan wage hour,
Okay.
stating that money was owed me, and it was paid in full.
You agree that the PTO is after 90 days work and they're entitled to 1 week salary?
Yes, if they completed their.
Right. And how many days did he complete? Can you tell me?
I can.
And are all employees on probation for the first 90 working days?
Yes.
Why are you writing down period of time unauthorized deductions, June 23?
So they did not inform me that they were gonna be taking money out of my account. I was informed about the withdrawal out of my account until the bank informed me about it.
Do you have proof of some kind that you worked 90 days? Okay, let me see that.
Actually, Your Honor, I apologize, I did not, because I do not have. I was not given my employee handbook to start the company.
You have proof that he didn't work 90 days.
Other than the fact that he had not successfully completed it because he was on a performance improvement plan. And then our manual states that if you get discharged, you don't get PTO.
Yeah, but what if he worked 90 working days and then he was discharged?
He still wasn't entitled. Even if he had the PTO, he wasn't entitled to be paid it out because our manual says you don't get paid PTO if you're discharged.
Do you have that manual? Let me see that.
I don't know. He was on it. That's.
Which page?
On the front, there's 3 different.
I know, I was hoping you could direct me to a page.
Page 11 is one of the pages. I hand wrote on the very front. There.
Okay. This. It does say that when a disciplinary dismissal occurs, the employee will receive any remaining earned pay, and unused benefits will not be paid due to damages and undue burden to the company.
They went through it and it's statement that I got,
I'm sorry, say that again?
that's the statement I got back from Michigan Wage and Hour. That was for, failed paid time off. Wow.
Um, you filled this out, right?
Yes.
Pardon?
Yes, Your Honor.
Where was there a finding that they said you were entitled to this, though?
One second.
Did you ever receive a finding saying that he was entitled to this, the company?
She's saying that he had said that things were squared away, basically. I did not get anything saying.
Yeah, oh, I apologize, Your Honor. That's right.
So they didn't really rule in your favor, though. They said Department of Labor and Economic Opportunity Wage and Hour Division's records indicate payment has been made, which satisfies a portion of your claim. The balance of your claim has been closed per your withdrawal. Why couldn't they have been looking at that and saying it was essentially paid twice, and then you call them up and say, hey, I want to file this claim, and you got their money twice, and now you withdraw the rest?
Sorry.
Yeah, I know that wasn't very artfully stated. You agree you got paid twice, right?
Yes, I do.
Okay. Okay, so the question is whether you deserve the second check. You filed a complaint, and it looks like they somehow determined that you were paid in a portion of what you were claiming, and that then you told them forget the rest. How do I know that isn't on the amount that you should not have been paid if you weren't entitled to PTO?
Your Honor, I talked to them on the phone. I had told them that they were treating money on my account. I disputed it and gave it back. They said that all monies were paid by then. That's what I was told by Michigan Wage.
But you got it twice. I'm going to give you a chance to tell me why I'm wrong, and I could be wrong, but it sounds like you got paid twice and you weren't entitled to PTO to me,
Yeah,
at least according to the handbook.
you got paid for 40 straight hours and 6.52 overtime hours. So even if we owed the PTO, which we didn't, based on the manual, it was still more than 40 hours and he was paid twice.
Your Honor, I've also got right here the messages that this is the only time I was notified that they would be taking money out of my account, was once they got notified that I had disputed it.
That's not true.
Okay, let me see it. Let me see what you have.
And I've also got threats with, we got messages that can go through my pay as well.
June 19th, I notified him that I was cutting a check for that reimbursement. And he gave me permission to protect his data.
Wait 1 second. Wait. Looking at this young man, and I'm seeing that according to this book, you weren't entitled to PTO. And it seems like that's what all that this comes down to at this point. I'm not saying the dismissal was or wasn't warranted. But they make clear an employee may be dismissed at any time for any reason, but usually for disciplinary reasons at the sole and absolute discretion of management. I mean, you're clearly an at-will employee. In case of dismissal, your company may have at its sole discretion, give some notice if it's intent to dismiss an employee, but the company is not required to give any such notice. This is consistent with management's intent to follow the doctrine of employment at will. When a disciplinary dismissal occurs, the employee will receive any remaining earned pay, which you got, and unused benefits will not be paid.
Is there any problem that I see that paperwork?
No. No. I mean, I don't have any signature from anybody here. This is the employee handbook. How do I know that he got this?
Everybody's given it, and then there's also a copy that is on board, for reading, all of our required documents.
I mean, you just probably hang it like this, right?
Yeah.
You don't separate out by page the 39 pages and post them across the board, right?
Just like.
And you are 100% convinced he didn't work 90 business days.
You're on that pay stubs that I can show that I did work 30 days.
Is it day, let me ask you, in this employee manual, if somebody's, let's say it's Christmas Day as an example, and they don't work, is that considered a work day? Let me just check the thing, please. Let me ask you a question. When they get to 90 work days, they're not dismissed. What happens? They have to come in and say, hey, can I have my PTO check?
Yeah, no, because people will request those days off because they've been 5 days to use between then and their next anniversary day as a vacation, paid time off, they're not following. But we have a meeting to discuss.
If you want to run home and get your documents and come back with them, I don't think, I'm not saying that even if you have proof of 90 days that I can give you this money. I'll let you go get it if you want.
You're on the so I have the pay stubs, because they had removed the pay stubs out of the account, Gusto. So I do not have pay stubs from at all working at the fix. I have bank statements from.
You are under oath. You're swearing under oath. You checked and double checked this, and he did not work 90 business days.
Like I said, even if he hadn't successfully completed it because he was on the verge of getting fired.
I got it. I got it. So in a way, it's just paying them to take a vacation, right?
It's giving them vacation days, yes, sir.
Young man,
Yes, sir.
I'm sorry. We just cannot rule in your favor. Judgment for plaintiff. Now we can set up something. Can you pay this, or do you want to set up a payment plan? And you have a check with you? You have any problem with him going to get a check, bringing it back, handing it to you, and then we'll agree to do a dismissal order? Okay. Linda, I want to make sure that that happens. You go run home, get a check, and bring that back. And then I will make sure that I do a, Linda, have them do a dismissal order, a stip in order to dismiss, please, okay?
Okay.
Thank you. Philip Trevino versus Moran.
Dawn says who uses checks nowadays? The same people that are going to stop by the malt shop on the way. It's definitely a little old timey, especially here in the 21st century. Let's go back to Judge Boyd.
All right, what are we here for, Mr. Martinez?
Restitution hearing, Your Honor, or at least a check-in on the, if anything had been turned in to the state for probation.
Judge, at this time, we've not received any dollar amount estimate or any documents from the complainant regarding restitution.
All right. So the court is calling 2025 CR 0000072, State versus John Anthony Martinez. Could I have parties announced?
Megan Galloway for the state.
Leo Gonzalez for John Martinez.
And are you Mr. Martinez?
Yes, Your Honor.
All right, we're here for a restitution hearing. It's the court's understanding that states you've received no documentation or information with regards to restitution?
Yes, Your Honor, the complainant in the case has been given the opportunity to be heard by the state, and they have not provided any documentation or estimates to the state at this time regarding restitution.
All right, and the court will note for the record that the defendant entered a plea and was placed on probation July 21st, 2025, and it is now September 22nd, 2025. The court will order no restitution. Ms. Abrams, on John Anthony Martinez, there's to be no restitution. And we get off the record. So any issues with probation?
No, ma'am.
All right, thank you.
Thank you.
Have a good day.
Your Honor, that's all I have. Maybe excuse.
Yes.
Thank you very much.
All right, that was a quick one. Let's go over to Judge Stevens.
715 Montreal Lotfoot. You have to speak out so she can hear you.
Montreal Lotfoot.
Okay, okay. You are here with Mr. Burbank, your attorney, and the state's attorney is present. You were charged with the third-degree felony of deadly conduct, discharge of a firearm, which carries with it up to 10 years in prison. Do you understand?
Yes, ma'am.
All right, this states that the defendant, probable cause affidavit I'm referring to in the file here. And that the defendant and another person fired multiple rifle rounds into an apartment complex parking lot, resulting in 2 people sustaining gunshot wounds. And multiple apartments, occupied and unoccupied, were struck by gunfire, as well as multiple vehicles were hit. And according to the surveillance footage here, AR-15 AR-15 style rifles were used in the commission of this offense and this shooting. Montreal Lightfoot is identified as one of the persons involved in the firing of the weapons. What is his bond now? Are you asking for a reduction in bond?
Yeah.
What is his bond right now?
Yeah.
Right, because I. Stand by.
$150,000.
Which apartments are these? It says 4610 Maddox. I'm not. What's the name of that apartment complex?
Judge, I've just compared, we had to sort out who all was handling these. There are 6 co-defendants, and I now actually have all the cases. There is an apartment complex that is located on East Virginia and Maddox, but I apologize, I don't know the name of it, Judge. But that is where this happened.
Yeah, on Lightfoot, what do you want to say? Mr. Burbank, you're asking for a reduction of bond, and the bond is $150,000. Is that what it is?
Yes.
Go ahead.
I can put him on if you want.
What do you want to do? Whatever you want.
We're asking for a reduction to 50,000.
What do you want to do? Do you want to put him on?
I can put him on if you need to.
I don't need to, whatever you
I
want.
can shortcut it.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing, sir, will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And please state your full name.
Montreal Lightfoot.
Okay, and your date of birth is September 29th. To speak out.
Yes, sir.
Okay. Yes, everything. Yeah, you nod and shake your head. It doesn't work. She's got to take everything down so that we can have it for a record. Go ahead, Mr. Burbank.
Montreal, how old are you?
18.
18. And do you have any bank accounts or any money that you could possibly post a $150,000 bond?
No, sir.
Do you have any vehicles? Do you have any property that you could put up as collateral for a bond?
Absolutely.
Prior to being incarcerated, well, how long have you been in jail?
4.5 minutes.
4.5 months. And before that time, were you a resident of Belmont?
Mm-hmm.
And who were you living with?
My mom.
And your mom. And if you were to be able to post bond and get out, would you go back with your mom?
Yes, sir.
Where does she live?
Straightaway.
Straightaway? Okay, and she has a place for you to stay, correct?
Yes,
You
sir.
can get rid of your bed, huh?
Yes, sir.
If you were to get out too, you would abide by all the rules and conditions.
Yes, sir.
One might be a GPS. They want to know where you're at.
Yes, sir.
Would you be able to do that?
Yes, sir.
There may be a curfew saying that you can't go out all hours of the night. Would you be able to do that?
Yes, sir.
And you're asking for a bond reduction at this time?
Yes, sir.
We're asking your honor that it be reduced down to 50,000.
Stay. Any questions?
Did you graduate from high school, sir?
No, sir.
Are my records accurate that you've not been arrested before? Never had any juvenile history either, is that correct?
No.
Those are my only questions, Jeff. Or the defendant.
Look, the court is looking at the public safety report as courts are required to do on taking issues of bond. I'm looking at this report. It was printed out on June 13th. of 2025. And it states that the defendant, among other things, it discusses the charge here in this indictment 25 CR 715, deadly conduct, discharge of a firearm. And it also states the defendant was in July of 23, evading arrest or detention, a Class A misdemeanor, was referred I guess juvenile disposition. May 26, 2023, illegal possession of a dangerous drug, a Class A misdemeanor, that was referred. On November 15th, 2021, state jail felony of unauthorized use of a motor vehicle, that was adjudicated, and the defendant was placed on 1-year probation. And on November 15th, 2021, also an evading arrest with detention, a 3rd-degree felony, adjudicated, placed on probation with the unauthorized use of a motor vehicle for 1 year. That's what this is. That true? Okay, that's not what you told him.
I believe he was talking about his adult side.
Whatever.
No, I asked specifically
That's not
about
what he asked. He asked for anything. It was a global question. But the point is that the public safety report is made a part of the record in this, for this hearing, and sealed otherwise, because this is going to be dealing with some juvenile behavior. So this isn't the first time you've been arrested, is what this says. And this isn't the first time you've been before a court and a proceeding for criminal matters. So you know how it is. You know that consequences, actions have consequences. Good actions are bad, have bad consequences. Here, the court is looking at the probable cause affidavit, where there are numerous assault rifle rounds fired in a multi-family dwelling apartment complex here in this city. At looks like about noontime. And you and another person were apparently identified as being the or among the people involved in the firing of those weapons. And the 2 people were shot, multiple apartments struck by gunfire, and multiple vehicles hit. In this city, this is like a bad movie. We're not going to put up with obnoxious, bizarre, violent, random behavior where people in an apartment complex, you have all sorts of people from young to old, where you have bullets flying around. This is absurd behavior in a life that we've had enough of violence. We don't want irresponsible behavior, and we certainly don't want people shot or in harm's way. And we don't want an environment where in the middle of the day, there are assault weapons being fired among the homes, multifamily dwellings in this city. We won't tolerate it. And you know, from your previous criminal involvement with the crimes of evading arrest, illegal possession of drugs, unauthorized use of a motor vehicle, evading arrests, those all have consequences. and you were placed on a form of probation, it looks like juvenile, so you know that this is serious. But it's the law. We're supposed to live peaceably in this country, much less this city. And it's what we make of it. We are not going to tolerate wild behavior like this, where people are in harm's way. Only takes one bullet to kill someone. Your bond is, if it were me, I'd raise it. I don't tolerate this. The people in the city don't want chaos, especially someone who's been through this criminal system before. Shame on you. So the bond is not dismissed, it is not reduced. If he posts a bond, if you post a bond, you must have a GPS device. You will be at home confinement. You will not leave your home except for necessary reasons and with the court's prior permission. Any reason I want to have, I know what it is, and I'm going to be the determiner whether you're going to be allowed to leave the home or not. But this is chaos, and the people don't tolerate this. No civilized group would ever tolerate this. Shameless. And anybody else who pulls stunts like this. How many rounds were recovered?
That's a good question,
Judge.
Numerous? It was a lot. I
Yeah,
remember
only
that.
takes, that's one for each soul who was at risk.
One of
Could
the
have
things-
killed a whole bunch of people.
It sent two different people to the hospital, Judge.
Killed them. But people's homes and vehicles were damaged. Chaos. That's not tolerated. Shame on you. And anybody else involved with that. Shame on you. So, no. You can sit in custody until we get this thing finished.
I'd ask that we place on the trial.
It's set for trial.
Move this on.
Sure. Sure. Let's set for trial and get it fast tracked. I want a jury to hear this and to decide his fate as soon as possible.
If I could, I'd like to get all the defendants on the same trial document.
It's on
I can make sure they are set together. Jenny.
okay. Did I give you back? Did I give you that? Let me look at it just real quick.
One other thing for your honor's education, in this young man's 130 days in the jail, he's had 9 what they label criminal incidents. So his behavior in the jail is not.
What am I supposed to do?
I'm just educating the court that you're certainly made the absolute right decision based upon his behavior in pending custody, Judge.
Okay. But it's based. I didn't know that information.
Yes, sir.
But I guess I'm not surprised based upon the public safety report, the criminal history, and the probable cause affidavit. You're free falling. You don't care about anybody else. The others, your creator should be first, other people second, and then you third. That's what all humans should be. We should be selfless, not carrying around weapons that can kill anybody and erratically firing those in multifamily dwellings and at calls. The fact that there weren't 20 or 30 people killed here by you, I guess, is a miracle. But it wasn't because of your brilliant thinking. It's just God's will prevented that from happening. But we are going to step in and control you as best we can. Everybody has free choice, and your choices are poor. Anything else?
Not from the state. Thank you, Judge.
All right, Cavante Willis, come forward, please. Thank you.
As I pointed out earlier, this is a co-defendant from that same fact pattern.
I have 2 cases here, though. I only have 1.
That's because he's a convicted felon, Judge. He was charged with unlawful possession of firearms. See, Bert?
Yeah.
This is the same occurrence?
Same fact pattern, yes, sir.
Come on up.
And it's
Two
the
cases are
state
now
belief
called.
he was handling one of the weapons, Judge.
Two cases are now called, 25 CR 716 and 717. Cavante Willis, is that you?
Yes, sir.
You were here with your attorney, Mr. Lodge, and the state's attorney. Sir, in 25 CR 716, this indictment handed up on June 11th, as well as 25 CR 717 handed up by the grand jury on June 11th. In 716, this alleges in paragraph 1 that on or about May 5th, 2025 in Jefferson County, Texas, he committed the third-degree felony of deadly conduct by discharging a firearm at or in the direction of others. And then paragraph 2 goes on to allege that you have been convicted out of Lafayette Parish, Louisiana in 2021 for robbery. So if you are found guilty of this third-degree felony of deadly conduct, and this prior conviction was indeed deemed valid and admitted at a hearing, your punishment range becomes a second-degree felony, which means you are looking at no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. Plus, you would not be eligible for probation in front of a jury if this prior conviction. You going to interrupt me? Yeah, let's follow the rules for a change. That's why you're here. We all follow, and we all have to follow the rules. But you get in trouble when you don't. So once again, a jury cannot grant probation in this state for someone previously convicted of a felony if this is deemed valid. And finally, in 25 CR 717, in this case, you are indicted with the third-degree felony of unlawful possession of a firearm by a previously convicted felon. On or about May 5th, 2025, when you committed this deadly conduct, it is alleged you were possessing a firearm, which then enhances your punishment if you are a convicted felon, as 716 indictment alleges that 2021 conviction for robbery out of Lafayette Parish, Louisiana, shows that you are a convictee. So you are ineligible to possess a firearm if you were previously convicted of a felony in this. It's unlawful in this state to possess a firearm in this manner if you have a prior conviction, and it's a third-degree felony, which carries with it up to 10 years in prison. So totally, you're looking at up to 30 years confinement is what you're exposed to. And in this deadly conduct, whatever sentence you get, it would not be paroled until you served 1/2 of your sentence on this deadly conduct. So if you receive a 20-year sentence, you won't see light of day in the free world until you've served at least 10 years confinement in prison, and you're not eligible for probation. So you've gotten yourself into a box here. You got to deal with it responsibly. She's a fine lawyer. I'd follow her advice if I were you. Do you understand what you're charged with and what the punishment range is here in each of these cases? Why are we here? It's a hearing on what?
Bail reduction.
What is his violence?
Just on the deadly conduct, it's $50,000.
I'm sorry, it's one.
$50,000, and on the unlawful possession of a firearm, it's $100,000.
So total, it's $100,000 on each case, correct?
150.
$150,000 in both cases added up.
Yes, sir.
Okay. It's your motion. Go
Thank
ahead.
you,
Yes,
Jay.
ma'am.
I'd like to call my client.
Raise your right hand. You solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God. Lower your hand.
And you're gonna have to speak up for the public reporter to hear you, okay? Mr. Willis, will you tell us how old you are
22 years old.
and how old were you at the time of the incident?
This incident already,
Yes.
I'm 22.
Okay.
I wasn't here with this incident, so
Okay, do you have any current bank accounts or cash on hand that you could use to help pay this bond?
Yes, ma'am.
How much do you have available?
I don't know. It's my daughter bank account.
Do you have the funds available to pay the
Yeah, my mom should have.
the entire $150,000?
Not the entire $150,000.
Okay. Do you have any property that you could use for collateral to pay the entire $150,000?
I don't think so.
All right. Who were you living with before?
My mother.
And if you were to be released on bond, if you were able to pay your bond, who would you go to live with?
My mother.
And she would still want you to live with her?
Yes, ma'am.
And she resides in Jefferson County?
Yes, ma'am.
Okay. And if you are released or able to pay the bond, you understand that that may come with some conditions?
Yes, ma'am.
Conditions that might include you to wear an ankle monitor,
Yes, ma'am.
conditions that might require you to be homebound.
Yes, ma'am.
Okay, and you're prepared to follow any of those terms and conditions?
Yes, ma'am.
All right. Judge, we are asking for a reduction in bond down to $50,000.
And she had asked you a question. I just want to make sure that we all think about this real hard. She asked you, and you can follow all conditions that a court would set.
Yes, sir.
There's not a doubt about
No doubt about
May I?
it. So help you God.
it. Can I say something real quick?
Yes, sir.
See, I was already on probation before, but I had completed my probation. Why am I not eligible for probation again?
I'll talk to you about that after this hearing, if that's okay, Judge.
Okay.
May I ask questions?
Go ahead.
You are Cavante Willits,
Yes, sir.
spelling Kevontay.
Yes, sir.
Your date of birth is December 4th, 2002.
Yes, sir.
You were convicted in the Lafayette Parish in Louisiana on August 26, 2021
Yes, sir.
for the offense of simple robbery
Yes, sir.
in cause number CR-179579 in the 15th Judicial District Court located there.
Yes, sir.
Yes, sir.
Yeah.
And on that, you received for that offense, you did receive looks like the equivalent of some kind of probation where you were sentenced for 3 years, but hard labor, but it was probated for 3 years.
Yes, sir.
You were just referencing to the court that you had finished that probation.
Yes, sir.
When did you finish the probation?
I finished in 2024 around March.
Okay, go ahead.
Show your picture that's in there. Is that individual you?
Yes, sir.
So you're not disputing the fact that you've been convicted before of simple robbery from that
Yes, sir.
deal that we've been talking about. All right, so let's talk about your conduct in jail. My records indicate that you have been in custody for 129 days, true?
Yes, sir.
My records indicate that you have been reported for different incidents of not following the rules starting in June 11th of 2025, all the way up until right before you appeared here in court on the date of September 21st, 2025, yesterday.
Yes, sir.
You want to modify your answer to that you gave the judge that you have the ability to follow rules?
Yes, sir. See, most of them cases I got in fights, but like I got jumped and all them situations, like when it was my fault. Just I'm not from around here, so just I don't know how to explain it.
I don't have any other questions along those lines, Judge.
Okay.
Anything else would be about the offense. and
Let
I'm
me
not gonna
ask you
go
about the
there.
probation that you were previously on. How did that get disposed of?
You completed the terms of that
Yeah.
probation, correct?
I completed the probation.
Or for 3 years? It was a 3-year term of
Yes, sir.
probation?
It was a 3 and 7 if I violated.
Was it February of 21.
Yes, sir.
No, that's the arrest date.
I believe
When
that.
were you placed on
conviction date
probation?
was August
August. Yeah,
21.
August of 21.
August of 21, which means he's been a little over 4 years.
But when did he get off of, when was he released from probation?
Last year.
In 24.
24. Yes, sir.
The actual notes in our record says he was released unsatisfactory. That's from the custodian of the records for the PIN packet that was
Yeah, I'm not sure
received
what
and
that
uploaded.
exactly means. That's, doesn't sound good, but I don't know what it means, really.
And in fairness to all of us, Your Honor, I also don't know what that means. From his understanding, he completed the probation. He didn't get any further.
Sentence?
Yes, so.
So it ended with a probation, but it's a regular probation. He was found guilty.
Yes.
Not deferred.
Regular-
You were
regular
found
probation.
guilty beyond a reasonable doubt. That probation was not dismissed, though, and exonerated. He wasn't.
Correct.
It-
It's our equivalent of a straight, it's our equivalent of a straight
So
probation, yes, sir.
So you have, and that's why this is alleged here as a prior conviction in paragraph 2, which they're going to argue at trial feasibly that you're not eligible for probation because of this, if it's proven true beyond a reasonable doubt, and that the punishment range is enhanced. It's higher because of that.
And it's that conviction the state is relying on for him to be a felon in possession of firearm, Judge.
And just for judge's clarification, what age were you at the time of that conviction?
17.
17 at the age of that conviction, Judge.
Did you know better?
Yes, sir.
What?
At the time, I know better.
I was 17 months. I know better than
Yes, I know
to
better
commit
now.
robberies.
Yes,
I mean,
sir.
how old do you have to be to know that a violent crime is real? All right, I have the public safety report as well for this record, which was printed on June 13th, 2025 of defendant Devontae Todrick Keon Willis, date of birth December 4th, 2002, FBI number R as in Robert 0320. P as in Paul, J as in John, W as in William 1. It is a document of 3 pages, which will be made a part of the record for all purposes for this hearing, since the courts are bound to recognize and review the public safety report of an individual who is the subject matter of a bond hearing now under Texas law. And it has the criminal history of the defendant as well as the new charges. All right, you're asking Ms. Naraj for.
Yes, Your Honor, we're asking for a reduction in that amount to 50,000, something that is potentially capable for him to pay.
I understand. The court has also reviewed the probable cause affidavit in this case. And again, this is a most aggravated, serious case where multiple rounds of AR-15 style rifles were fired into vehicles and apartment units of a multi-dwelling apartment complex in this city of Beaumont, Jefferson County, Texas. And 7.62 and 5.56 caliber rounds connected to assault style weapons were fired in this case. And the current bond, the court feels is proper based upon the circumstances of this case and the defendant's criminal history. And shame on anyone who is so irresponsible to fire assault weapons at midday into apartment units and vehicles at a multi-family dwelling facility like this apartment complex here in Beaumont, your bond is not reduced. If you can post the bond in this case, you will be placed on home confinement. You must have a GPS device. You cannot leave your residence under those circumstances unless a permission is granted ahead of time by this court. Do you understand where you are? And this is all due to the circumstances of this crime and your criminal history. Anything else?
Yeah.
That is all. Thank you.
I have a question.
Yeah, you can talk to her.
Yeah,
Okay.
I can talk to you.
Carly Fowler? Carly Fowler,
Judge, that was me.
that was reset. And then we've got, I had Monica Vincent. Did we reset that?
Judge,
And then on Anthony Spruill, John Best.
no,
Go ahead.
no idea.
There you go. I did.
Okay. We're in recess. Please, let's get ready to pick up the trial. Thank you.
Okay, well, he goes to recess. Let's go to Louisiana. I believe they're doing pardons today. Let's see what's going on there.
Good morning. Would you introduce yourself, ma'am? Tell us your name and your current mailing address.
Yes, ma'am. My legal name now is Deborah Trishelle. My physical address is 2.
I'm going to read some identifying information into the record and just ask you to confirm it. Your case this morning has been assigned to Ms. Stapleton to my left. He'll take the lead on the interview. So you are here this morning, Ms. Jordan, seeking pardon with restoration of firearms. You were sentenced in Richland Parish in August of 2015, possession of Schedule 1 marijuana. You received and possession of Schedule 4 diazepam. You received a 3-year sentence that was suspended, and you were placed on 3 years of active supervised probation.
Correct, and drug work.
In drug.
I completed drug work.
Okay. And let me just, before I turn it over to Mrs. Stapleton, I want to recognize you have your parents here today. Welcome. We have Judy and Mark London, and I think at the appropriate time, your father wants to say a few words. Mrs. Stapleton?
Yes, go ahead and tell me, I'm reading the case, what you were arrested for, but you go ahead and tell me what happened and what you were arrested for. I did notice also that your child was in the car when all this happened.
Yes, ma'am. He was. I was plain and simple, just not living right. I was a broken human. I had gone through something pretty traumatic prior to that, and made some really stupid choices. Because to be quite frank, I didn't know how to process emotion. I compartmentalized everything. It's a rough upbringing. And after that traumatic experience, I just lost myself. I did. And that particular day, I had been dating someone, and that person had kind of accosted me on my road or whatever, and reached into my truck and grabbed some stuff, and I went and I was on my way to pick my child up. Picked my child up, and whenever I came back, law enforcement was there waiting for me at the end of my road. I had a Valium in my possession, and I had approximately a gram of marijuana in my possession. I'll be honest with you, I did not know that the Valium was there. I had the marijuana. I did eventually find out how the Valium got there. It was not by accident. But at the end of the day, I put myself in that situation. I put myself around that person. I created the environment that allowed it to happen. So, you know, I answered for it. I made a lot of bad mistakes.
You mind if I call you Deborah?
Yeah.
Okay. Well, Deborah, I noticed that, like you were talking about drug court, it was an 8-month inpatient rehab.
Yes, ma'am.
And you satisfied all the conditions of your sentence. You haven't gotten into any trouble since then, Deborah?
Absolutely not. I didn't speak. I'm gonna blow your mind for real. I went to work in the prison system.
Well, good for you. Yeah, all right. And tell me why you need, the pardon and why you need it with the firearms. Tell me that, please.
Okay, after going through what I went through and healing, I had a lot of healing to do, and my parents are here, so they know, it was rough in my house. It was a violent home, lots of drugs, lots of craziness, but it was the norm, you know, but I wasn't a bad kid. I grew up, because I wanted to be everything that I wanted to be the opposite of everything that my family was, you know. And did well in high school, graduated from high school, went to college, decided I wanted to join the Army instead, and went to the Army. I planned on that being my career, but I got injured and sent home. And it was heartbreaking for me.
Yes.
So I went into nursing and nursed for some time until I blew my life up.
Well, so you got your nursing degree?
I do, but let me tell you, so, you know, they took my nursing license.
Because of the drug.
Actually, no, because of my ex-husband. Because of my ex-husband. He's the one that brought drugs in our home. And I allowed him to. I created the environment. That was my part in the situation. And because of that, the State Board of Nursing determined that that was the same thing as participating in the behavior by allowing him in my home. At the time, I couldn't see that. Obviously, it was my husband. But yeah, 100%. But if I had booted him out, I wouldn't be here today, standing in front of y'all. Everything happened for a reason, every bit of it. It's always been my desire, because of the way that I grew up. I believe in law, I believe in order, and I believe that people should be held accountable for their actions. Truth be told, the Department of Corrections did not whoop me nearly as hard as they could have.
Yes, that's true.
And I'm grateful for that. I'm so grateful.
Drug court a lot of times intervenes in that, and if a person's successful, that's their way of not spending a lot of time in jail. But you have to be determined to do it.
And I was, September 7th, 2015. I had to turn myself in. And my life has never been the same since. And here we are, 10 years and 15 days later, and I'm standing in front of you guys. But I knew on September 7th, 2015 that I would be. I knew that.
So what do you do?
I talked to God about it.
So what do you do in the prison system?
I was a lieutenant, shift lieutenant.
Good for you. You still work there?
I did, and I had to leave to get another job because I couldn't make enough money there because I couldn't get my post certification.
Oh, you couldn't get your post cert? I got mine at 50 years old.
Yeah.
Oh, because you couldn't have a gun, that's why you couldn't.
Couldn't get my
Gotcha.
post certification.
Okay, well, I'm finished with questions. Does anyone else have any?
And the warden, I want to mention some very important people, that made a difference in my life. Judge Terry Dougie was one of those.
Okay.
He wasn't just a judge. He cared about humans. He cared about seeing people be successful in life and have successful lives. His own father was an alcoholic.
Yeah.
And, man, when I tell you he lashed me. My very first sanction, 12 days into drug court, and I didn't come back for 8 months. And after the 8 months in rehab, I went to work for that rehab. And I stayed there for 4 years, and I'm still in contact with a lot of the girls. It was important to me to share what I had been through to try to inspire and give people hope and show them, you know, it's never too late. It's never too late. And I'm grateful to be here. God's grace and mercy is so abundant, and I am so excited and gung-ho about having the opportunity to make a difference.
Well, I'm gonna tell you something. Most people's purpose and calling in life quite often comes from their own pain. And it brings them to do things that they wouldn't normally have done, but then they're grateful for it, that they're there. Like you say, to share and make a difference.
My family wouldn't be what it is had I not gone through that. It brought us together. It brought us to God. It brought them to God. It changed him.
Did you wanna recognize?
Yeah, we already did. If Mr. London would like to speak, you want to go ahead and
Yes, ma'am.
do that?
Thank you.
You gonna speak? She was, absolutely right about violence. I was born in 1960, so I come up fresh out of high school, using marijuana. I thought that was the coolest thing ever. And my dad is a police officer for 20 years. My little police boy, he begged me to go to the military or be a gang warden. All I'm gonna do is hunt fish. But I chose to see the dope and alcohol. And years rocked on, and I met my wife in a little town called Uranium in about 1980. In 1982, we were living together for many years. Got married in 1998, been together ever since. But during that time in 1980s, I got addicted to powder cocaine. And I was a bad person, violent, fought a lot, got in trouble. Abusive to my wife. There was abusive to Danielle, but I was abusive to my wife, verbally and physically. Was arrested many times. Thank God I was never convicted of a felony. Long story short, Danielle saw a lot of stuff as a child. Right there.
It's okay.
Okay.
I'm not proud of it. But we struggled through it, we made it through it. I got help. I relapsed maybe once or twice. And in 2000, I went to work for Sheriff Fuel. I was up there at the Sheriff's office, stayed there 5 years. Politics got kicked out, but I went to the pipeline, her and I did, we made it. And I watched Danielle struggle. She's worked from day one. When she left high school, she has never not had a job. She is a real go-getter. She's been very, very proactive in everything she's talking about. She's a people person. She loves to make a difference in people's lives. She steps out and talks to people and just cares for people. And tells them about the Lord and what she went through and what God's done for her. And it is awesome what he can do for you if you get it.
Well, she's made an excellent impression on me.
Oh, yeah.
I can only speak for myself.
But yeah, she is a wonderful person now, and she is dedicated. She strives every day to do better, and she is seeking higher job opportunities she wants to.
And that's the purpose for needing the file.
Oh, yeah.
Yeah, Miss, she pointed that out to me. I wasn't thinking in post, yeah, you have to qualify with a weapon.
Okay.
Certainly do. Okay, thank you very much.
Yes,
Do you have
ma'am.
anything else you need to say or that covers?
I just very much, and I'm so proud that y'all let us come here today to hear the story and pray that everything works out.
Okay, thank you, sir.
Yes, ma'am. Thank you.
Ms. Jordan, you must step back up. All right, are there any other questions?
Yeah.
Mr. Prater, have any questions?
No, thank you.
So I think we're prepared to vote, Ms. Jordan. We'll start with Mrs. Stapleton.
Okay, based upon your history since. And you made an excellent impression on me, Deborah, this morning. And I wish you every happiness and success in your future. See no reason why you won't have it. My vote today is to grant your pardon with restoration of firearms.
Mr. Prater,
Concur.
Mr. Freeman,
I concur. You've done excellent.
Thank you.
We appreciate it.
Mr. Tillis.
My vote is to grant.
And my
With
vote is-
restoration.
my vote is to vote.
Okay, the probation and parole, y'all.
Make a recommendation for pardon with restoration of firearms. The DA, you need to know, the DA was opposed to the restoration of firearms. but neither sheriff in Richland or Caldwell Parish were opposed. So you've received a unanimous vote for, to make the recommendation for a pardon with restoration of firearms. And so we're gonna make that recommendation on your behalf. Yeah.
Approved? Well, that was fun. Every now and then we get a good one like that. We'll finish off our day with Judge Boyd.
Could somebody let that attorney know? It's just that the issue is on not appearing for courts. I want to say part of the new law is you don't get a bond, but I'm trying to make sure that's the case. All right, so what is happening with this case?
Judge, so the last time that we were here, the defendant had an indicted unauthorized use of a motor vehicle, I believe. Discovery is complete in that case. However, I had to reach out to the arresting agency because there's an additional first-degree felony investigation that's stemming from that. So I did reach out to get the status. The detective that's currently investigating that first-degree felony is out. So I did reach out to the department that's investigating the case to see the status of that. So I'm waiting to hear back. And then the defendant also has an ag assault that's pending. Discovery is not quite complete on that. We're just pending a phone dump that I've requested from the detective that they are to provide me, but they have to reach out to their tech unit to obtain that and then get it to me.
Okay, so this is what I can tell you. We have other cases that are set before yours. We have murder cases, capital murder cases, sex cases that are all set before you. Your case, if you all decide to have a jury trial, it's probably going to be set in the new year. So this is what I'm going to do. I'm going to give you a November setting date so everyone can make sure that they have all of their discovery and then state at that time if you will be prepared to tender an offer.
Yes, Your Honor.
All right, Ms. Ferguson, if you can set this in November, put it for close to the last date before we have our Thanksgiving vacation.
Judge, in addition, it's not on the docket, but we have.
Just 1 second.
Oh,
Let me
I'm
get
sorry.
this. All right, November 17th. And on that date, discovery plus an offer is due. All right, yes, counsel.
Judge, we've got a motion to modify on file pertaining to GPS and requesting to modify from partial to tracking, Your Honor. I've got a copy of the motion. I did show the state and just trying to determine if the court wants to take it up or set us at a later time. The state's opposed, Judge.
State, are you ready to take this up?
I am, Your Honor.
Okay. And Norma, Demonte Williams, he's only on one page, correct? Yeah. All righty. So the court is calling 2025 CR 010277 State versus Demonte LaRobert Williams. Can I have parties announced?
Megan Galloway for the state.
Will Brooks for the defendant, Mr. Williams, Judge.
And are you Mr. Williams?
Yes, ma'am.
All right, your client has filed a motion requesting that bond conditions be amended. State, are you ready to proceed?
Yes, sir. This time, state is opposed for tracking, and we would ask the court that the conditions remain as they are. And at this time, we would offer B1 and B2 for purposes of this hearing.
No objections for purposes of this hearing, Judge.
All right. And I'm sorry, what were the exhibits again?
B1 and B2.
All right. States exhibits B1 and B2 are admitted without objections for purposes of this hearing only. Excuse me. All right. The court has reviewed states exhibits B1 and B2. And any witnesses state other than those exhibits?
No witnesses, Your Honor.
All right, defense, any witnesses?
Just argument, Judge.
All right, the court will hear argument.
You want to hear from me,
Yeah.
Judge? Okay. In respect to the offense reports, Judge, there are allegations at this point. We're contesting those allegations. We're going down that path. In respect to the request itself, Judge, in the motion, I've lined out a history of his supervision on this case. I believe in December, before I was appointed to Mr. Williams, there was like a zone inclusion violation. His conditions were amended at that time to full house arrest. Since that time, Judge, he's had no violation reports. His conditions of bail have been amended, I think in March of this year, to partial to allow him to attend doctor's appointments and then to work doctor's appointments in respect to a new child that he has. We're asking the court to consider tracking at this point for two reasons. One, him to be able to care at a higher level for that child, if that makes sense, Judge. And then for employment purposes, it is difficult sometimes for certain types of jobs and employment for them to be able to provide notice in a sufficient amount of time. So for those reasons, Judge, we're asking for the alternate amendment to the tracking rather than the partial that he's currently on.
Judge, at this time we're opposed. It's the state's understanding that the defendant is currently on partial. It sounds like he does not have steady employment currently. And so given that fact, the state is opposed to tracking only based on the allegations that are contained within State's Exhibit B1 and B2. We are asking that the court deny the defense's motion for tracking based on safety for the community and the complainant in each case, Your Honor.
All right, this is what the court is going to do. The court will do tracking with a curfew. So if you all can come to an agreement on the curfew, and that's what the court will do.
Sure.
All right, thank you. All right, can I see the parties back on?
Okay, friends, that is it for today. I hope you all had fun. I know I did. If we have to have a Monday, this is a good way to spend it, is with each other, watching some court and having some fun. Look forward to seeing you tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. And tomorrow night we'll have Sidebar as well with special guest panelist Lindsay. So that should be a lot of fun as well. Go have yourselves a great Monday. Make the best of it. We'll see you tomorrow. Take care. God bless.